araw sa ating lahat mga idol at mga kababayan. Patuloy po nating pag-uusapan ito pong patungkol sa barangay at sangguniang kabataan eleksyon. So, yun nga pong Republic Act 12232, kahit po yun po ay Republic Act na, mga idol at mga kababayan, ay hindi pa rin po talaga 100% na mapopospon ito hong December 1, 2025 barangay at sangguniang kabataan eleksyon, sapagkat meron nga pong nag-question na yun nga po si Atty. Makalintal at si Barry Tayam ng Las Piñas. So ngayon po yung status ng Republic Act 12232 ay pinagkokomento nga po itong COMELEC, yung Senado, maging ang Kongreso. Pati rin po yung opisina ng ating Pangulo ay pinagkokomento po ng Supreme Court patungkol po doon sa petisyon na inihain po ni Atty. Romulo Makalintal. So binibigyan po ng pagkakataon yung COMELEC, yung Senado, yung Kongreso, maging yung opisina ng ating Pangulo para po kanilang depensahan yung batas na kanila pong ginawa o yung Republic Act 12232. Uulitin ko po mga idol at mga bayan, ito po yung katotohanan sapagkat hindi pa po talaga tapos yung usapin patungkol dito po sa barangay at sangguniang kabataan eleksyon, sapagkat meron nga pong nag-question, hindi pa po 100% na matutuloy yung November 2. Hindi pa rin po sigurado na talagang mapopospon o hindi po matutuloy itong December 1. Unang-una, hinahanapan po ng valid na rason yung atin pong mga mambabatas kung bakit po nila gustong ipagpaliban itong December 1, 2025. So yung nakasulat po doon sa Section 5 o sa Omnibus Election, mga idol at mga bayan, na kapag ka magpopospon ng halalan yung COMELEC po hindi po yung Kongreso, sapagkat yung Kongreso po ay wala hong karapatan na magpospon ng halalan. Sila po ay may karapatan na mag-fix ng termino. Pero doon sa kanilang pag-fix ng termino ay wala dapat masagasaan. Hindi dapat na ipospon yung halalan, sapagkat pwede naman po silang mag-fix ng termino nang hindi po ipinagpapaliban yung halalan, mga idol at mga bayan. So pwede naman nilang i-fix yung termino, pero yung December 1 ay ituloy. At yung mga mananalo dito sa December 1, 2025, sila yung magkakaroon ng fix na termino, na ang gusto nga po ng ating pong mga mambabatas ay 4-year 3 terms. Ibig sabihin, kada isang taon, 4 na taon yung laman. Kada isang termino pala. Kada isang termino ay 4 na taon yung laman. Ibig sabihin, every 4 years magkakaroon ng eleksyon. Yun po ay yung gusto ng ating pong mga mambabatas. So, hindi po sapat na dahilan kaya sila magpopospon ng eleksyon kasi magpipix sila ng termino. That's not a valid reason to postpone the barangay at sangguniang kabataan election ngayong December 1, 2025, sapagkat meron na nga pong Supreme Court ruling na noong pinuspon po nila yung halalan noong 2022 ay nagkaroon nga po ng pagpetisyon, pinitisyon ni Atty. Makalintal, question doon sa Supreme Court, yung legalidad ng RA 11935 o Republic Act 11935. Yun po yung batas na pinupuspon po nila, yung 2022 Barangay at Sangguniang Kabataan. So nagkaroon po ng oral argument at napatunayan po na yung Republic Act 11935 ay labag sa batas, unconstitutional, mga idol at mga kababayan. So, ibig sabihin lamang po ay wala po talagang kapangyarihan yung Kongreso na mag-postpone ng halalan, mga idol at mga bayan. Sapagkat yung pagpo-postpone po ng halalan ay nasa kapangyarihan lamang po ng COMELEC. Pero, binigyan po ng guidelines yung COMELEC. Kung sakali po sila ay magpo-postpone ng halalan, dapat po merong mabigat na kadahilanan, merong valid na rason para i-postpone po nila yung halalan. Katulad po, kunyari ng may matinding kalamidad, katulad po ng tsunami, o kaya pagkasira ng mga kagamitan na gagamitin po sa eleksyon. Siyempre, kung napunit o nabasa yung mga balota, siyempre talagang hindi matutuloy. Yun po yung tinatawag na failure of election. Yun po yung mga valid na rason para po i-postpone yung halalan. So sa nakikita natin ngayon ay wala naman po ngayong wala namang karahasan, wala namang giyera, wala namang tsunami, salamat sa Diyos. O, ibig sabihin ay hindi po dapat na ipagpaliban, dapat po na ituloy itong schedule ng Barangay at Sangguniang Kabataan eleksyon na nakatakda nga po ngayong December 1, 2025. Supreme Court po yung nagtakda nito, mga idol at mga bayan. At napagsabihan na po, sapagkat naideklara nga po na unconstitutional, labag po sa batas, yun pong ginawa nilang postponement noon. Ngayon, meron na pong ibinigay na guidelines yung Supreme Court na kung sakaling magpo-postpone nga po ng halalan, dapat merong mabigat na dahilan. At meron nga pong Supreme Court ruling na bawal po i-postpone yung halalan, mga idol at mga bayan. Pero ano po ang ginagawa? Ano po ang ginawa ng ating pong mga mambabatas? Binaliwala po nila. Binaliwala po nila yung sinabi ng Korte Suprema. Ibig sabihin po, hindi nila kinikilala yung Supreme Court ruling. Hindi po nila nire-respeto kung ano po yung sinabi ng ating pong mga justices ng ating pong Korte Suprema. Sapagkat yan po ay dumaan na sa oral argument, yung postponement na yan. Pero sinasabi ng iba, yung Republic Act 12232 ay hindi daw po postponement. Hindi daw po postponement sapagkat yung nakalagay doon ay fixing the term. An act fixing the term, mga idol at mga bayan. Na yun nga po, sabi ni Attorney Makalintal, ay batas na panlilinlang. May halong panlilinlang, yan pong Republic Act 12232. Sapagkat nakalagay nga po doon ay fixing the term, pero yung magiging epekto, makikita nyo mga idol, magiging epekto po nito ay postponement nitong original na naka-schedule, na in-schedule nga po ng Supreme Court, December 1, 2025. Talagang meron tayong makikitang postponement. Sapagkat kung hindi po matutuloy itong December 1, 2025, ano po ang ibig sabihin noon mga idol at mga bayan? Ibig sabihin po talaga ay merong postponement. Diba? Kapag kayong schedule ay hindi natuloy, ibig sabihin postpone. Napakaliwanag po, maliwanag pa po sa sikat ng araw, ngayong katanghali ang tapat mga bayan. So meron po talagang postponement. Sana po ay wag malinlang yung atin pong mga justices dito po sa batas na ito. Sapagkat yung ating Pangulo ay nalinlang na po. Nalinlang nitong batas na ito. Sapagkat sabi nga po ng Supreme Court, bawal yung postponement. Napakahigpit po. Mahigpit po yung kabawalan ng Supreme Court patungkol po sa postponement o sa pagpapaliban ng batas. Pero pinayagan pa rin ng ating Pangulo. Pinayagan pa rin ng ating Pangulo sa pamamagitan ng kanyang paglagda na mapuspon itong December 1, 2025 na itinakda nga po ng Supreme Court, mga idol at mga bayan. Ibig sabihin lamang po, baka sa mga susunod na buwan, baka bumaba yung tiwala o yung trust rating ng ating Pangulo sapagkat pinapayagan niya yung paglabag sa konstitusyon, mga idol at mga bayan. Tayo po ay nasa panig lamang po kung ano yung nasa konstitusyon, yun po yung dapat na sundin natin. Dapat natin galangin yung kung ano po yung pong nasa konstitusyon o kung ano po yung nasa batas, mga idol at mga kababayan. Tuloy yan, Lods, sa December 1, 2025, 4 years, 3 terms, correct. Pwede man sabihin ng Supreme Court, di ba? Kasi yung unconstitutional lamang dito, mga idol mga bayan, ay yung pagpapaliban ng December 1, 2025. Pero yung 4-year 3 terms ay hindi po yan unconstitutional sapagkat nasa kapangyarihan nga po ng ating pong Kongreso na mag-fix ng termino. So yung tingin ko dito, mga idol at mga bayan, sa tingin ko, siguro before filing ng Certificate of Candidacy, kasi yung umpisa po ng pagpapail ng COC or Certificate of Candidacy ng mga tatakbo sa barangay at sangguniang kabataan eleksyon ay magsisimula po October 1 hanggang 7. October 1 hanggang October 7. Ibig sabihin po, sana nga po mga idol mga sana nga po before yung October 1 ay meron ng desisyon yung atin pong Supreme Court. Pero sa palagay ko ay talagang ganun. Talagang makapagdidesisyon na yung Supreme Court before October 1. Yun po yung nakikita ko, mga idol mga bayan. Sapagkat napakabilis ng aksyon ng Supreme Court. Di ba? Naghain po ng petisyon si Atty. Macalintal kamakailan lamang po matapos pirmahan ng ating Pangulo. Tapos ilang araw, 2 days lang yata yun, ay nag-response na. Pinakokomento na ng Supreme Court yung atin pong Kongreso, yung Senado, yung COMELEC, maging po yung opisina ng ating Pangulo para depensahan po nila yung batas na kanila pong ginawa. So nakikita ko po na talagang mabilis yung aksyon ng Supreme Court patungkol po dito sa pagpapaliban po ng barangay at sangguniang kabataan eleksyon. So sa palagay ko, before October 1 ay meron ng desisyon yung ating pong Korte Suprema kung talagang ipopospone o talagang matutuloy itong December 1, 2025. Pero sa nakikita ko, malakas po yung depensa ni Atty. Macalintal. Sapagkat unang-una yung itinakda ng ating pong mga mambabatas na schedule na gusto po nila November 2, 2026. Na paulit-ulit nga po natin na sinasabi na yung November 2 ay paggunita po sa atin pong mga mahal sa buhay na yumao. Araw po ng kaluluwa. Akalain mo merong mga nagpapadasal tapos hahaluan mo ng politika. Hindi naman pwede yan, mga idol mga bayan. Yan po ay kabastusan, kawalang respeto doon po sa atin pong mga yumao. Kaya yun po yung isa sa nakikita ko. Isa pa mga idol at mga bayan na nakikita natin na dahilan kung bakit matibay po yung pinanghahawakan ni Atty. Macalintal. Sapagkat meron na nga pong desisyon noon yung Supreme Court na yung postponement ay mahigpit po na ipinagbabawal ng Korte Suprema. Sapagkat kapag ka na-postpone itong December 1, 2025, ibig sabihin, mga idol at mga bayan, ay ma-extend ng isang taon yung panunungkulan ng atin pong mga barangay officials na yun po ay labag sa batas na i-extend mo basta-basta ng walang mandato ng taong bayan yung isang barangay official. Sapagkat ayon po sa batas, yung isa pong barangay officials ay dapat po na inahalal, ine-elect, pinagbubutuhan. Hindi basta-basta ina-appoint. Isa pa, mga idol mga bayan, hindi po pwedeng idepensa ng atin pong mga mambabatas kung bakit nila pinopospone ito pong December 1, 2025 sapagkat merong daw barm election. Pagod daw sila. Kasi yung kanila hong dahilan noon ay pagod daw sa eleksyon. Kasi katatapos lamang po noong presidential election noong 2022, kaya nila pinuspon yung barangay at sangguniang kabataan. So hindi po valid na rason yung pagod sa eleksyon o election fatigue, mga idol at mga bayan. So yung talagang pinaka-valid na rason lamang, mga idol at mga bayan, na ibinigay sa Commission on Election kung sakali po sila ay magpo-postpone, dapat po talaga merong matinding kadahilanan, mga idol at mga bayan. Katulad ng pagkasira ng mga kagamitan o mga election paraphernalia, halimbawa nabasa yung unang sira, yun pong mga balota, o kaya merong karahasan, merong gyera, merong tsunami, yun po talaga yung mga valid na rason para masabi nating i-postpone dapat yung eleksyon. Pero sa nakikita natin ngayon ay wala naman pong ganoon. Bakit kaya nila pinopostpone itong December 1, 2025? Sapagkat meron tayong nabalitaan na yan daw po ay ipinangako ng atin pong mga mambabatas doon sa barangay officials, doon sa mga kapitan, na kapag sila ay manalo doon sa midterm election na yon, ay i-extend yung termino, ipopospone itong December 1, 2025, mga idol at mga bayan. So ito na po yung tinutupad na nila, yung kanilang pangako sa mga barangay officials. Na yun din po ang sabi ni Atty. Makalintal. At mayroon din tayo napanood na talagang pinangakuan yun pong kapitan na kapag nanalo yung babatas na ito, ay i-extend talaga yung kanilang termino, mga idol at mga bayan. So hindi rin po pwedeng idahilan o irason na 2 years lang yung kanilang iuupo, yung kanilang magiging panunungkulan. Kasi kung maalala nyo, last 2023 po ng October, isinagawa yun pong barangay at sangguniang kabataan eleksyon. Kaya yung mangyayari, 2023, tapos kung matutuloy itong 2025, ilalabas talaga na 2 taon lamang po uupo o manunungkulan yun pong mga nanalo noong 2023. So sapat ba na dahilan na kulang sa termino o kulang yung panunungkulan? Sapat ba na dahilan na 2 years lang yung kanilang iupo? Kaya dapat i-extend para maging tatlong taon naman. Yun po yung sabi ng iba, mga idol. Yan po ay hindi po valid na rason na kulang sa termino. Sapagkat ang nakasulat po doon sa batas, mga idol at mga bayan, na yung mga lokal na opisyal lamang po, mga local officials lamang po, katulad ng mayor, vice mayor, mga konsihal ng bayan, gobernador, vice gobernador, sila po yung binigyan ng fixed na termino na 3 taon. Kapag lumampas sila sa 3 taon o kumulang, ibig sabihin ay labag talaga sa batas yan. Except barangay officials. Magkaiba po yun, yung local officials, ito yung mga mayor, vice mayor, governor, iba din po yung barangay officials. Yung barangay officials po ay iba po, hindi po sila binigyan ng 3 taon na fixed na termino. Hindi po nakapix talaga yung termino ng ating pong mga barangay officials. Kaya hindi mo pwedeng sabihin na unconstitutional kung 2 years lang yung kanilang iupo, mga idol at mga bayan. Sapagkat pwede yung pahabain, pwede rin pong paiksiin. So kapag maiksi, hindi po unconstitutional. Kapag mahaba pala, ay hindi rin po unconstitutional sapagkat nasa Kongreso po yung kapangyarihan na magtakda, mga idol, ng termino ng ating pong mga barangay officials. Lamang sa kanilang pagtatakda ay hindi dapat masagasaan, hindi dapat mapuspon yung eleksyon, mga idol at mga bayan. So ibig sabihin lamang po, mga idol at mga bayan, ituloy ang eleksyon ngayong December 1, 2025 at yung mga mananalo dito sa December 1, 2025, sila yung magkakaroon ng fixed na termino. Wala sanang problema kapag kaganon. Di ba mga idol mga bayan? Sapagkat wala tayong nasasagasaan. Wala tayong naipagpapaliban. Wala tayong napopospon halalan sapagkat yung postponement ay mahigpit po na kabawalan ng Supreme Court na bawal po yung postponement, mga idol at mga bayan. Pwede naman po nilang i-fix yung termino ng ating pong mga barangay officials, pero hindi po dapat na i-postpone yung halalan o eleksyon, mga idol at mga bayan. So napaka matibay po yung batayan ni Attorney Makalintal patungkol nga po dito sa postponement ng barangay at sangguniang kabataan eleksyon. Nanalo na pala itong si Attorney Makalintal doon sa isinagawang oral argument doon po sa Supreme Court noong 2022 postponement. Kaso nga lang, talagang na-postpone yun pong halalan o hindi po natuloy yung December 2022, December 5, 2022, sapagkat late na nakapagdesisyon yung atin pong Supreme Court, mga idol at mga bayan. Kaya natuloy yung 2023. Sa palagay ko, mga idol at mga bayan, hindi na po hahayaan ng Supreme Court na maulit yung pagkakamali noon. Hindi na po hahayaan ng Supreme Court na malate yung kanilang pagdidesisyon sapagkat nagkaroon na nga po ng oral argument noon na yung postponement ay labag po sa batas, unconstitutional, mga idol at mga kababayan. So ibig sabihin lamang po, pagka hindi po natuloy itong December 1, ibig sabihin po, postpone. Napakaliwanag pa, postpone po. Pagka hindi po yung natuloy yung original na schedule, ang tawag po doon ay postpone. Talagang meron talagang postponement. Wag ho tayong bulag-bulagan, mga kababayan ko. At alam niyo ba, talagang napakarami po ng gusto na matuloy itong December 1, 2025. Kagaya po ng katatapos lamang po na voters registration. Akalain niyo umabot po sa 2.8 million, million po ito mga kababayan, 2.8 million yung mga nagparehistro sa loob lamang po ng 10 araw, mga idol at mga bayan. Ganun po karami yung interesado na makaboto o makapamili ng kanilang mga leader sa kanilang mga barangay. Sapagkat kapag pinuspon talaga itong halalan, ibig sabihin lamang po ay tinatanggalan na naman tayo ng karapatan para mamili ng atin pong mga leader sa atin pong mga barangay. O kapag matutuloy ang eleksyon sa December 1, kawawa ang mga kapituko. Kawawa ang mga kapituko. Si Randy Porda, shoutout po sa iyo. Magbubog ka na boss, ikaw na lang magbalita dyan. Tapos na, kahit ulitin mo pa, batas na yan. Hindi naiintindihan, pinagsasabi mo boss, mag-aral ka kasi. Hindi kayo nakakaintindi Eh di kung tapos na talaga, wala na sanang usapin patungkol dito. Ikaso nga po, hindi pa po 100% na mapupuspon itong December 1, 2025 sapagkat meron nga pong nag-question. Tanggapin niyo po yung question ni Attorney Makalintal doon sa Supreme Court. Baka magulat tayo, bukas makalawa ay may desisyon na yung Supreme Court na ituloy yung eleksyon at ngayong December 1, 2025 at yung mananalo ngayong December 1, 2025, sila yung magkakaroon ng fixed na termino na 4-year 3 terms pa lang, mga idol at mga bayan. Pwedeng ganun yung gabi ng Supreme Court, mga idol. Pinapahirapan ang mga tao sa kahihintay. Correct. Dapat makapag-desisyon na talaga itong Korte Suprema. Ang kailangan namin ay ang final. Nakakasawa maghintay. Magantay lang po tayo sapagkat dumadaan po yan sa tamang proseso. Bias din tong taong to, parang si Joyner Singh. Paano tayo magiging bias? Sinasabi lamang po natin kung ano po yung katotohanan. Na talagang hindi pa po 100% mga bayan. Hindi pa po talaga 100% na mapopospon itong halalan o eleksyon ngayong December 1, 2025 sapagkat meron nga pong nag-question. Maganda sana kung wala. Talagang sasabihin namin na postpone na. Kaso nga po, merong nag-question. Tanggapin niyo po yung, yung balita natin mga idol at mabayan, na hindi pa po talaga 100% na mapopospon itong December 1, 2025. Ang importante sa konstitusyon, 3 years, 1 term noon. Ngayon, iba naman. Kaya nga, paiba-iba ha. Binabago po ng ating pong mga mambabatas. Pinagulo lang nila. Totoo, pinagulo lang nila. Puro kang ngal-ngal dyan, maghintay ka kung ano ang desisyon sa Korte Suprema. May desisyon na po noon ha, na yung postponement nga po ibawal. Ikaso makukulit ha, makukulit itong ating pong mga mababatas. Talagang pinuspon pa rin nila. Kung ano yung kagustuhan nila, yun pa rin po yung gusto nilang masunod. Hindi niya po nila ginagalang kung ano po yung sinabi ng ating pong kataas-taasang hukuman o ng ating pong Korte Suprema. Dapat lang matuloy ang eleksyon. Sabi ni Rolando Buiteson, ayan, shoutout po sa iyo. So ngayon ay panonoorin po natin ha, alang-alang po doon sa mga hindi pa po nakapanood, ay sinagawang oral argument. Noong 2022 ito ha, uulitin ko po. Itong mapapanood po natin ay oral argument noong postponement noong 2022, mga idol at mga kababayan. So, may upload po tayo kanina ha, kanina pa lang umaga, na yun po ay presentation ni Atty. Makalintal doon po sa oral argument. So ito po, mapapanood natin yung kabuuan ng oral argument. Mahigit 3 hours yata yun. Ayan, pagsagaan nyo. Pero kung hindi kayo interesado na manood, pwede naman po yung umikset. Pero kung gusto mong panood yung oral argument, ito po, panonoorin po natin, mga bayan.
Thank you, Atty. Makalintal. May belief from the Solicitor General.
Ayan po, si Solicitor General.
Good afternoon again, Your Honors. Mr. Chief Justice, members of this most honorable Supreme Court, may please the court. Elections are at the bedrock of our democracy. Regular elections foster rule by the governed instead of rule by political elites. These propositions are self-evident and invite no further debate. However, they do not in themselves prove that every electoral postponement is anathema to a democratic and representative government. On the contrary, an election forced under less than optimal conditions may wreak greater havoc on our democracy compared to a temporary postponement decreed by legislative fiat. This danger especially rings true when, as in this case, the mechanism entrusted by the Constitution for the delivery of election services will be rushed to ensure its conduct even under severe constraints of time and resources. Mr. Chief Justice, Your Honors, questions relating to the postponement of elections and its resultant effect on the term of barangay officials have been raised before this court in the past. This court, in many of its decisions, COMELEC versus Cruz and David versus COMELEC among them, deferred the resolution of these questions to the wisdom of Congress. That Congress has the power to decide this question is beyond cavil. The Constitution vests in Congress the power of legislation. This power is plenary in character and embraces the subject of election postponements, scheduling or rescheduling, subject only to the limits imposed by the Constitution. It is in the exercise of this power that the two houses of Congress enacted Republic Act number 11935, postponing the December 2022 Barangay and Sangguniang Kabataan elections. Congress has exercised this power in several instances in the past. It did so 2 years ago when it postponed the barangay elections because of public health concerns on account of the pandemic. It did so again this July when it passed Republic Act number 11935 and moved the date of the elections for barangay and SK officials from 5 December 2022 to the last Monday of October 2023. Judicial scrutiny of the validity of these postponements, while permissible under the court's expanded power of judicial review, is only allowed under very narrow limits. As this court held in COMELEC versus Cruz, such scrutiny may only happen in two instances. One, when there is grave abuse of discretion on the part of Congress. Or two, when the postponement of barangay elections clearly violates any constitutional standard. Petitioner himself has not attributed to Congress any abuse of discretion in the enactment of Republic Act number 11935. And as respondents will make abundantly clear, this postponement of the barangay elections made by Congress does not violate any constitutional standard. Mr. Chief Justice, Your Honors, the exercise by Congress of its legislative power to postpone the barangay elections to 2023 does not intrude into the power of the Commission on Elections to decide all questions affecting elections. This power, enshrined in Section 2, Paragraph 3, Article 9-C of the Constitution, does not include the power to set the date of elections. The phrase affecting elections in this clause presupposes a priorly set elections. As such, COMELEC's power to decide questions affecting elections is confined to the conduct of matters of an operational nature relative to the holding of elections. This is made evident by the qualifying phrase in Section 2, Paragraph 3, Article 9-C of the Constitution, which clarifies by way of example those matters included within COMELEC's power to decide. The examples set by the Constitution, such as the number and location of polling places, the appointment of election officials and inspectors, and the registration of voters, are clearly operational matters. They do not include setting the date of elections. Section 8, Article 6, and Section 4, Article 7 of the Constitution constitute textual authority for the proposition that the power to fix the date of an election is legislative in character. These provisions fix the regular election of members of Congress and of the President and Vice President on the second Monday of May, unless otherwise provided by law. By allowing the date of the election for these national officials to be alternatively fixed by law, the Constitution expressly granted the legislature the power to change the date of their election from that fixed by the Constitution. Respondents submit that if the Constitution grants Congress this power, So far as the election of national leaders is concerned, with all the more reason should this power be recognized to reside in Congress in respect of the date of election of barangay officials. Moreover, the power of the COMELEC to postpone an election is not traceable to any provision of the Constitution. It is statutory in character, granted to COMELEC pursuant to Section 5 of Batas Pambansa Bilang 881, otherwise known as the Omnibus Election Code. This statutorily granted power is limited. It is exercisable only under the circumstances and conditions set forth in BP 881. More importantly, it can be withdrawn by Congress by amendment or repeal. Mr. Chief Justice, Your Honors, the validity of the postponement of the barangay election cannot be challenged on the ground that it will result in the retroactive lengthening of the term of incumbent barangay officials, or that it amounts standard. In the words of this court, and I quote, "The closest the issue of retroactivity of laws can get to a genuine constitutional issue is if a law's retroactive application will impair vested rights. Otherwise stated, if a right has already vested in an individual and a subsequent law effectively takes it away, a genuine due process issue may arise. But there is no deprivation of any vested right in this case. Contrary to petitioner's claim, the postponement of the barangay elections effected by Congress deprives neither political contestants nor the electorate of the right to due process. The postponement effected by RA 11935 is not open-ended. On the contrary, Congress postponed our barangay elections to a fixed later date. This evinces a clear intent on the part of our legislators to inform both the sovereign electorate of a definite date, 12 months from now, when they shall exercise their right to suffrage, and the political contestants of the day certain when the electoral contest for barangay office will be held. This postponement, therefore, does not deprive the sovereign electorate of their right to vote. Neither does it violate the constitutional guarantee under Section 26, Article 2, of equal access to public service. For apart from the delay of 10 months in the exercise of these rights, which length of time even petitioner has not claimed to be unreasonable, RA number 11935 places no restrictions or conditions on the right to vote or on the right to run for barangay office. Meanwhile, the holdover provision of RA number 11935 cannot be construed as a legislative appointment in favor of incumbent barangay officials who may be indirectly benefited thereby. In the first place, an appointment is a process that takes several steps to complete. It involves, among others, selection, acceptance by the appointee, and assumption to a previously vacant office. It requires discretion on the part of the appointing authority. None of these are extant in the case of barangay officials allowed to stay in a holdover capacity. Congress makes no selection on who may serve the extended term of a barangay official. No acceptance is required of the appointee, and there is no reassumption as the office in question is not vacated. Most importantly, there is no discretion exercised. For in reality, what transpires is not an appointment. In the second place, the delivery of public service, albeit on a holdover capacity, is legally allowed for this class of officials. Such mandate vests in the incumbent official on account of practical necessity, not by some whim or caprice on the part of the Congress. This holdover mandate has found judicial approbation in Sambarani versus COMELEC and again in ADAP versus COMELEC. In these cases, this court upheld the application of the holdover principle for this class of officials to preserve the continuity in transaction of official business and to prevent hiatus in government service. Finally, the validity of RA number 11935 cannot be challenged on the ground that it violates the one subject, one title rule enshrined in Section 26, Paragraph 1, Article 6 of the Constitution. This rule is intended to prevent surprise or fraud upon the legislature and apprise the people of the contents of a proposed legislation. However, it does not require the transformation of the title of the proposed legislation into a complete index of its contents. As such, the general repealing clause found in Section 6 of RA number 11935 need not be reflected in its very title. Mr. Chief Justice, Your Honors, the barangay and SK elections were previously set on 5 December 2022. Pursuant to constitutional and statutory mandate, the COMELEC embarked on adequate administrative and operational preparations towards the holding of these elections. These preparations included, among others, voter registration, drafting the calendar of activities and implementing resolutions for the conduct of the elections, procurement projects for the supplies, materials, and services necessary thereto, and printing of official ballots. The enactment of RA number 11935 compelled COMELEC to put a halt to these preparations. In our consultations, COMELEC has made clear that it is now impossible to hold the elections on 5 December 2022 in view of the passage of RA number 11935 and the consequent suspension of the preparatory activities crucial to the conduct of the barangay elections. Forcing the holding of elections under these circumstances may have far-reaching implications on our democracy and in the trust and confidence of the electorate on the outcome of these important electoral exercises. Respondents therefore pray of this most honorable court the dismissal of the petition. Mr. Chief Justice, Your Honors, thank you, and may it please the court.
Thank you, Mr. Solicitor General. The justices will interpolate the presenters, and they are free to ask any of the presenters. The first to ask is Justice Antonio Co. Justice Co. Thank you, Chief Justice. Petitioner Makalital, please. Good afternoon, Mr. Makalital.
Good afternoon, sir.
You filed the petition to assail the constitutionality of RA 11935 by invoking the expanded jurisdiction of this honorable court under Section 1, Article 8 of the Constitution. However, similar to the observation made earlier by the Solicitor General, I don't see any specific allegation in the petition of grave abuse of discretion on the part of Congress in enacting RA 11935. Can you explain this omission?
I think there is no omission, Your Honors, because when I filed this, I am also guided by some pronouncements of this honorable court that petitions for certiorari and prohibition are remedies that could be availed of to assail the constitutionality of legislative and executive enactments, and a direct invocation of this court's jurisdiction is allowed when there are special and important reasons, therefore clearly and especially set out in the petition. It is stated, Your Honor, in the nature of my petition.
Sorry. Yes, but under Section 1, Article 8, with respect to the expanded jurisdiction, the Constitution specifically states that there must be grave abuse of discretion. Nowhere in your petition you allege any specific act of grave abuse of discretion
Yes, Your Honor.
on the part of Congress in enacting this law.
Well, Your Honor, I think the submission of the Honorable Solicitor General is too technical, Your Honors, because I would submit, Your Honors, that when you question, when the issue is constitutionality and the law is considered as unconstitutional, then that clearly shows the abuse of discretion committed by Congress, Your Honors. That is my position, Your Honor. Don't have any more to state it clearly, but by the petition itself contesting the constitutionality, it involves the abuse of discretion. If this honorable court would find that the law is unconstitutional.
Okay, Mr. Petitioner, I noticed that in your petition, you did not include Congress, the House, as well as the Senate as part of the respondents. Considering that RA 11935 was an enactment of Congress, why did you not include them as respondents in this case to afford them the opportunity to defend RA 11935 before this court?
Because I believe, Your Honor, that by just impleading the office of the President, which will implement the law, and also the Commission on Elections, which will adhere to the implementation of the said law, that would be enough, Your Honors. And in previous cases which I filed before this honorable court, assailing some enactments of Congress, I did not include or implead members of Congress, Your Honors.
So,
And my petitions were duly given due course by the honorable court, Your Honors.
So, Mr. Petitioner, you don't consider the Congress, the House, as well as the Senate as an indispensable party in seeking a nullity of a law enacted by them?
In this case, Your Honor, I find no reason to have impleaded them, Your Honors.
Okay. Now, Mr. Petitioner, does the right to vote and elect public officials belong to the people?
Yes, Your Honor. As a matter of fact, the Constitution provides that qualified citizens have the right to vote, Your Honors.
In a representative democracy such as ours, would you agree that the people, by voting their representatives to Congress, have delegated some of the powers to Congress?
Yes, Your Honors.
Suppose the people delegated their power to postpone the election to the representative of Congress. Would the delegation be limited or absolute?
Well, if it is provided for in the Constitution, Your Honors, that Congress can postpone the barangay elections, then that would be an absolute right of Congress, Your Honors.
So,
But the enactment of a law must again yield to the rule that the law must be constitutional.
so what would be the limitation or the test of situations of limitation on the part of Congress to postpone an election?
Well, the limitation would be that what is provided for in the Constitution. For instance, in this case, Congress is allowed to determine the term of office of the barangay officials. So, once it is determined, it is as if that is already the provision of the Constitution, because once fixed, it cannot be refixed, Your Honors.
Okay. Without assuming its constitutionality or unconstitutionality, would RA 11935 qualify as a police power measure by Congress?
I don't know, Your Honor. I cannot get the...
Would the enactment of RA 11935 pursuant to the police power of Congress of the state?
I don't think the police power is involved in this case, Your Honors.
Okay. Now, RA 11935 postpones the 2022 BSKE or the Barangay and Sangguniang Kabataan election. You argue that it is in effect a deprivation of the right to suffrage. Am I correct?
Yes, Your Honors.
As a law that supposedly restricts the right to vote, as you argue, should RA 11935 be subject to what is known as the strict scrutiny test?
Yes, Your Honor. Republic Act 11935 should be strictly reviewed, Your Honors, because it violates the fundamental right of a person to vote. It, as I said earlier, Your Honor, it took away the voters' right to choose their own officials, because the law itself says that these barangay officials, whose term of office will end by December 2022, would have an extension of their term. And by extending their term of office, they are no longer elected officials. They are already practically appointed by Congress, Your Honors.
Okay. You said in your petition, Mr. Petitioner, that RA 11935 is void and unconstitutional because it encroaches upon the COMELEC's constitutional power to decide all questions relating to election, particularly in the postponement of the barangay and SK election, citing as basis items 2 and 3 of Section 2, Article 9C of the 1987 Constitution and Section 5 of the Omnibus Election Code.
Yes, Your Honor.
Okay. Let's go to item 2, Section 2, Article 9C of the 1987 Constitution. You will agree with me that it speaks of the quasi-judicial power of COMELEC to resolve all contests relating to election, returns, and qualification.
Yes, Your Honors.
If indeed, as you argued, that the power to postpone the barangay and the SK election belongs to COMELEC, item 2, Section 2, Article 9 of the 1987 Constitution will not apply, since the power to postpone an election is an exercise of what is known as the administrative power of COMELEC and not a quasi-judicial one. What can you say to that?
Well, the Omnibus Election Code, specifically the Constitution, Your Honors, gives COMELEC the exclusive power to postpone the election. Now, when Congress enacts a law postponing the election, then it is practically amending Section 5 of the Omnibus Election Code.
No, Mr. Petitioner, I'm citing particularly item 2, Section 2, Article 9C of the 1987 Constitution, which you cite as a ground to nullify this RA 11935.
Yes, Your
My
Honor.
question is, this particular item grants COMELEC quasi-judicial power, but in the postponement of election, it is not in the exercise of quasi-judicial power, but merely administrative power. So therefore, what I'm saying, do you agree with me that this item 2, section 2, article 9C of the 1987 Constitution does not apply and you cannot cite it as basis to nullify RA 119?
No, I still believe, Your Honor, that this could be used, Your Honor, to nullify, because it practically divests COMELEC of this power, Your Honor, to decide for itself whether or not the barangay election should be postponed.
Okay, let us proceed, Mr. Petitioner. You also agree that the postponement of an election adversely affects the right to vote of our people.
Yes, Your Honor.
In fact, in your petition, you argued that the said law, RA 11935, deprives the electorate of the right to suffrage to choose their barangay leaders. As you eloquently stated in your petition, and I quote, under this question law, Congress imposes or compels the electorate to accept their barangay leaders, whether the latter like it or not, for an extended period, beyond the three-year term for which they were elected. This runs counter to the very essence of the right of suffrage of our people, which is to choose the candidate of their choice.
Yes, Your Honor.
Oh. Since postponing the election affects the right to vote, which you concur, and item 3 now, I'm speaking of item 3, section 2, article 9C of the Constitution, specifically excluded from COMELEC the power to decide any matter involving the right to vote of our people. So therefore, you agree with me that item 3 now, section 2, article 9 of the 1987 Constitution, which you just cited, cannot be used to argue that the power to postpone an election, which affects the right to vote of our people, is lodged with COMELEC.
Well, I will still maintain, Your Honor, that the power to postpone is still with the Commission on Elections, Your Honors.
Despite the fact that the constitutional provision on section 2, item 3, specifically excluded those involving the right to vote, which you said RA 11935 did.
Oh, you mean the phrase except those
Yes,
involving the right to vote, Your Honors?
Earlier, you mentioned earlier that the RA 11935 adversely affected our people, the right to suffrage. So therefore, since it adversely affects the right to suffrage, this is an issue which the COMELEC can decide pursuant to this section 2, item 3, because it is it state here except those involving the right to vote.
Well, I have not dealt on this issue, Your Honor, in my petition, but my understanding, Your Honor, is that when the Constitution says that the COMELEC is given the right to decide all questions affecting elections, I would say that the postponement of the barangay elections done by Congress is included in this particular provision. Decide all questions affecting elections, but except the right to vote.
The right to vote. And since RA 11935, as you argued earlier, affects the right to suffrage of our voters, therefore COMELEC cannot decide on this matter.
No, Your Honor, it can still decide, Your Honor, because it involves questions affecting elections. Then it is still within the power of the Commission on Elections. Because we are talking here, Your Honor, of the postponement of the elections, Your Honors.
Okay. I'll proceed, Mr. Petitioner. You also rely on Section 5 of the Omnibus Election Code as a source of COMELEC's power to postpone an election. Would you agree with me that there's a distinction between a national election where we elect national public officials such as the president, vice senators, and a nationwide election where the electorate of the whole country elects its public officials regardless of national or local?
There is no distinction, Your Honor, as to the application of Section 5 of the Omnibus Election Code, Your Honors, as to whether it applies to national, local, or barangay elections. Because Section 5 of the Omnibus Election Code could be applied to any election, Your Honors.
Okay. Would you consider the barangay and the SK election a nationwide election?
Well, the barangay election, Your Honor, is a nationwide election. But in the case of the SK, Your Honors, I don't know if it could be considered as a nationwide election because not everybody actually is participating, as there are precincts which or there are barangays which have no registered voters at all, Your Honors.
Okay, now Mr. Petitioner, what are the country's political subdivisions?
What are the
Our country political subdivision as provided for under the local government?
well, we have the provinces and cities, municipalities, Your Honors.
Yes. So in this connection, I read a portion of Section 5 of the Omnibus Election Code on the postponement of election. Please allow me.
Yes, sir.
When for any serious cause, such as violence, terrorism, loss or destruction of election paraphernalia or records, force majeure, and other analogous causes of such a nature that the holding of a free, orderly, and honest election should become impossible in any political subdivision. I would like to stress on that. The Commission, motu proprio or upon a verified petition by an interested party and after due notice and hearing, whereby all interested parties are afforded equal opportunity to be heard, shall postpone the election. Thus, my question is, does a political subdivision refer to the entire nation?
No, not necessarily the entire, because the postponement could refer to one precinct, Your Honor, two precincts, one municipality, two municipalities, Your Honors.
And Section 5 allows COMELEC, therefore, to postpone the election, postpone the election only in a political subdivision, such as a province, city, and so on, but not the entire country. Because specifically, Section 5 only provided in any political subdivision, not the entire country.
Well, I believe, Your Honor, that the entire country, Your Honor, if there's serious reasons for the government to postpone the election, Your Honors.
So therefore, you're saying COMELEC can postpone a national
election upon petition, Your Honors, and upon due notice to all political parties.
despite the fact that Section 5 specifically mentioned that it's limited to any political subdivision.
Yes, Your Honors.
Okay. Obviously, Mr. Petitioner, the country is not a subdivision of its land. Okay. Mr. Petitioner, you agree that Section 5 of the Omnibus Election Code, that Section 5 of the Omnibus Election Code allows COMELEC to postpone the elections only on specific grounds.
Yes, Your Honors.
Let us assume, Mr. Petitioner, that the Legislative Department did not grant the power to postpone election to COMELEC under Section 5. When it,
Your Honor, might belong to the plenary power of the Congress, Your Honors. But when it postpones, there should not be any extension of term, and if there is any other election to be held, then that particular election should apply to the next period.
so therefore, you agree with me, Mr. Petitioner, that if there is no Section 5 under the Omnibus Election Code, the power to postpone belongs to Congress.
If there was no Section 5,
Yes. Now, considering that Section 5 of the Omnibus Election Code is limited in its scope and applicability to any political subdivision and only for specific grounds, you would agree with me that outside said scope and applicability, meaning on a nationwide basis, and for other grounds that Congress, in its wisdom, may provide, it is Congress that can act to postpone an election on a nationwide basis and for other grounds under its plenary power.
well, in this particular case, Your Honors, I am always referring to the act of Congress postponing the election and at the same time extending the term of office of the barangay officials, Your Honors. That is the main contention in my petition, Your Honors.
Okay. In your petition, Mr. Petitioner, Mr. Makalintal, you specifically stated in paragraph 1.2, and I quote, this petition does not assail the provisions of question RA 11935 pertaining to the election of Sangguniang Kabataan officials, considering that SK membership is a mere statutory right conferred by law and Congress may amend at any time the law to change or even withdraw the statutory right.
Yes, Your Honor.
So are you now changing your position on this matter?
No, only the SK, Your Honors, that I did not assail the postponement of the barangay of these SK elections because this SK, Your Honor, is not a local government unit, Your Honor. It is a youth organization, Your Honors.
Yes, Mr. Petitioner, correct me if I heard you correct earlier that you're saying that pursuant to RA 1965,
9164.
9164, pursuant to the provision therein that it must be synchronized.
It must be synchronized, Your
So
Honor.
you're changing your position now.
No, Your Honor. I would still submit, Your Honor, that in the event that a pronouncement is made by this honorable court that we should push through with the election, then the SK election should also be included because the law provides for a synchronized barangay and SK elections.
Because we are basing our decision based on your petition. And in the event we grant your petition and the barangay election will proceed on December 5, while the Sangguniang Kabataan will be postponed to October next year, would this not violate our Republic Act 9164, which mandates the barangay and SK election must be synchronized?
Not necessarily, Your Honor, because if this court would sustain my petition, then we push through with the December 5, 2022 elections, Your Honors, and following the law, Republic Act 9164, it must be synchronized with the Sangguniang Kabataan elections.
But you are not praying for the TRO with respect to the Sangguniang Kabataan.
No, Your Honor, because I believe that if my petition will be granted, it automatically follows that the Sangguniang Kabataan elections will push through because of the synchronization aspect of Republic Act 9164.
Okay. Mr. Makalintan, in your petition, you use the word fix in saying that the Constitution gives Congress the power to fix the term of office of barangay officials, citing as basis Section 8, Article 10 of the 1987 Constitution. However, you agree that the word fix does not appear at all in Section 8, Article 10 of the 1987 Constitution.
Yes, Your Honor.
Instead of the word fix, the word used is determine.
Determine, Your Honor. But
Can you explain? Can you explain why you use the word fix instead of determine? Since, for my own personal understanding, the word fix connotes the character of permanency, while determine does not.
well, it appears, Your Honors, that the words fix and determine as used in that particular provision is now used interchangeably, Your Honors. As a matter of fact, even in the oral arguments of the Honorable Solicitor General, it also mentions the fixed term.
Yes, but the Section 8, Article 10 of the 1987 Constitution does not use
Yes,
the word.
we agree with
So
that.
can we now, in these proceedings, avoid using the word fix to be faithful
To the
to
Constitution.
the Constitution by using the word determine?
I agree, Your Honor.
Okay, thank you, Mr. Petitioner. Incidentally, may Congress determine a different day for the national and local elections?
No, it cannot, Your Honors, because the Constitution had already determined that the elections will be on the second Monday of the year, Your Honor. Although the Constitution says that unless otherwise, Congress itself fixes another date.
So precisely, Congress now can determine a different day for the national and local elections because the Constitution specifically states that unless provided for.
Yes, I think so, Your Honor, in that particular aspect, Your Honor.
Okay. Does the Constitution provide a precise day for a barangay election?
As will be determined by Congress, Your Honors.
Okay. Would you agree, Mr. Petitioner, that the Constitution gave Congress the power to set a different term of office of barangay officials?
Yes, Your Honors. But the when you term, Your Honor, should be applied prospectively and not retroactively.
The local government code is an act of Congress. If you say that the Congress cannot amend, are you advocating a legal concept that when Congress pass a law, it cannot amend or even repeal, thus amounting to an irrepealable law?
Well, I agree, Your Honor, that it can amend, but the amendment must be in harmony with the Constitution. In this particular case, yes, it amends the law, it amended the law, but it is my submission that the amendment is contrary to the Constitution, Your Honors.
Okay. Now, I would like to focus now on your assertion that RA 11935 gave Congress the power to make legislative appointments of barangay officials, which you said is prohibited. You cited the dissenting opinion of Justice Velasco in Kida versus Senate. However, Justice Velasco, in using the term legislative appointment in said case, quoted a portion of the case of Osmeña versus COMELEC, a portion of which I will give. It has been broadly stated that the legislature cannot, by an act of postponing the election, fill an office, the term of which is limited by the Constitution, extend the term of incumbent beyond the period as limited by the Constitution. It has been declared, however, that legislation postponing an election which is not passed for the sole purpose of extending official term, but which merely affects an extension as an incidental result, does not affect the legislative appointment of his successor. In this respect, however, a distinction is sometimes drawn between constitutional and statutory offices. Postponement of an election by the legislature does not fly in the face of the Constitution so long as the postponement is reasonable and does not destroy the elected character of the office affected. What can you say to that, Mr. Petitioner?
Well, the excited jurisprudence, Your Honor, said that as long as the postponement is reasonable. Now, is this postponement reasonable, Your Honors? I don't think that the many or repeated postponements of barangay elections is reasonable. It is no longer reasonable, Your Honor. It is very, very unreasonable.
Okay. Now, I would like to ask your comment regarding the pronouncement of the chairman of COMELEC yesterday, which was published in ABS-CBN News, posted on, stated here, October 20, 2022 at 3:41 p.m. A portion of the news said, as far as this is a statement of quoted statement from the chairman of COMELEC, George Garcia. As far as the COMELEC is concerned, we prepared fully, but as of October 10, 2022, we slowed down because the law signed by the president. And so, if we will be asked if we are ready to hold election by December 5, we will say that there is no material time to proceed with the election. Before you answer, I would just like to call, if possible, the chairman of COMELEC, Mr. George Garcia, to confirm his statement. As quoted in this publication by ABS-CBN yesterday.
Good afternoon, Mr. Chief Justice, Your Honors. Your Honor, you are right. I was quoted rightly, and it was before I made that statement before the subcommittee of the Senate concerning the budget deliberation of the commissioner election.
Justice COMELEC, may I interrupt you? Mr. Chairman, I would like to ask you that I would like to tell you that whatever statements you made is considered under oath of in this proceeding.
Fully understood, Your Honor.
Thank you.
Thank you very much, Your Honor.
Can I proceed, Chief? Yeah, it's a petitioner. Can you comment on the statement made by the chairman of COMELEC that they cannot at this point in time proceed, or they cannot, it is impossible now to hold the election on December 5?
I don't believe, Your Honors, that the COMELEC is not capable of proceeding with the election. Maybe not on December 5, Your Honors, but on a date close, very close to the date of the election that is postponed, because that is provided for under Section 5 of the Omnibus Election Code. That while the COMELEC may postpone, it has still to continue with the election, Your Honor, on a date reasonably close to the date of the postponed election, after the cessation of the cause for the postponement, Your Honor.
But Mr. Petitioner, RA 11935 does not provide for any other date except the last Monday of October 2023. So therefore, this court will, you're saying, should ask Congress to enact another law,
No, Your Honor.
to set another date for the barangay and SK elections?
Because there is a provision, Your Honor, in the Omnibus Election Code, or RA 7166, that if the dates provided for under the law will not be reasonable to conduct a clean, honest, and orderly election, then the COMELEC is empowered to fix another date, Your Honors. I can discuss that in my memorandum, Your Honor. I just don't know the exact section of the law on that particular provision, Your Honor.
Thank you, Mr. Petitioner.
Maraming po salamat, sir.
Chief, can I proceed?
Yes.
Sarge, can I proceed
Go ahead.
with Respondents' Counsel?
Go ahead.
Mr. Solicitor General?
Good afternoon, Your Honor.
Good afternoon, Mr. Solicitor General. Article 10, Section 8 of the Constitution states that the term of office of elected local official, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. Pursuant to this provision, it is the Congress, through the enactment of a law, that determines the term of office of barangay officials. My question, can Congress provide for a term of office of barangay officials for a number of years and for any number of consecutive term as it deems proper? In other words, is the power of Congress to determine by law the term of office of barangay official unrestricted?
By the very wording, Your Honor, of Article 10, Section 8, as may be determined by law, it simply gives the impression that Congress is being given full discretion, full latitude to determine the length of the term of barangay officials and even the term limits for barangay officials. That seems to be the implication of the use of the word as may be determined by law.
Okay. Does the Constitution provide for any prohibition or limitation with respect to the length of the term and the allowable number of consecutive terms of office of barangay officials?
Well, basing it on the same constitutional provision, there appears to be none. Full discretion is given to the legislature.
Once Congress determines through a law the term of office of barangay officials, does this determination apply to a particular election period only, or does it apply to subsequent election periods?
Until that law is amended, then that law will continue to be in effect until such time that Congress changes it. So it does not apply to any particular election period. It will continue to apply for even for subsequent elections until such time that Congress finds it necessary to amend or repeal that law. Your Honor.
Thank you. Can Congress subsequently change the term of office of barangay officials through an amendment or repeal of a prior law fixing such term of office?
Your Honor, I think that that can be done because it's a legislative enactment and it's within the plenary power of Congress to amend, repeal, or modify any law which it has previously enacted.
Can Congress, pursuant to its authority under Article 10, Section 8, to determine the term of office of barangay official, postpone or cancel the scheduled barangay elections? In other words, does the power to determine the term of office includes the power to postpone or cancel a scheduled barangay election?
Your Honor, in our submission, we are saying that the power of Congress to postpone a barangay election is separate from its power to determine the term of barangay officials, their term of office. We are saying that the power to postpone barangay elections for such causes as, let's say, a health epidemic, like the COVID pandemic, Your Honor, arises from the Congress's plenary power and not necessarily from its power to fix the term. Because when Congress postpones a scheduled barangay election, it is for a specific reason and not for the purpose of affecting the term of the incumbent barangay officials.
Okay, so therefore, you agree with me that aside from the grounds cited in Section 5, Congress can, in its wisdom, provide for other causes or reasons or bases to cancel an election.
Definitely, Your Honor. Congress is not limited by the very limited grounds enumerated in Section 5 of Republic of BP 881 or the Omnibus Election Code.
Now, under Article 9C, Section 2, Item 3 of the Constitution, the Commission on Election is granted the power to decide, except those involving the right to vote, all questions affecting elections. Does this power of COMELEC to decide all questions affecting elections precludes the power of Congress to amend or repeal a law fixing the schedule of barangay elections?
Pardon me, Your Honor, who's precluded from amending?
Congress. Does this power of COMELEC to decide all questions affecting election precludes the power of Congress to amend or repeal a law fixing the schedule of barangay elections?
Definitely not, Your Honor. As I said, this power on the part of Congress is plenary.
Okay. Now, the totality of government power is said to be contained in three great powers of government: police power, the power of eminent domain, and the power of taxation. Considering that RA 11935 does not involve the taking of private property, nor does it impose any tax or revenue measure, then we can also agree that it involves a state exercise of police power. Do you agree, Mr. Solicitor General?
Your Honor, the matter of postponing elections may or may not involve police power, depending on the reason for the postponement.
Now, for particular this RA 11935, would you say that this is the enactment of this is in pursuant to the exercise of the legislature of the police power, of the state police power?
As far as I know, based on the journal and records of Congress, the matter of postponing this barangay election scheduled in December does not involve the state's police power, Your Honor.
Now, it appears from the title, Mr. Solicitor General, it does not explicitly provide any justifying reason for the postponement of the barangay election. Do you agree? There is no whereas clause there that says this is the reason.
Yes, Your Honor.
Now, the absence of any reason stated in the law itself, does it affect the validity or constitutionality of RA 11935?
No, I don't think it affects in any way the validity of the enactment, Your Honor. As I mentioned earlier during my opening statement, the matter of postponing elections is essentially a political question that goes into the wisdom. It's a question of policy on the part of the Congress. And unless there is a showing that there was grave abuse of discretion on the part of Congress, then we believe that judicial scrutiny is very much limited. And for that purpose, I think the reason why Congress does not include the reason for the postponement is that precisely it is a political question.
Now, I would like to ask my last question regarding COMELEC's preparation on whether it has logistical capability as of this time to conduct the barangay election on December 5, 2022. Earlier, Chairman Garcia already explained this statement stated yesterday that at this point in time, it is impossible for COMELEC to conduct the December 5, 2022 election. Can I request the chair to please approach and for some questions?
Thank you very much, Your Honor.
Mr. Chair, why do you say that it is impossible for COMELEC to conduct at this point in time the December 5, 2022 election?
Thank you very much, Your Honor. Upon the signing by the President on October 10, 2022 of the law, we suspended the printing of the ballots simply because the ballot does not reflect the date that the election will be continued, which will be October 31 of next year, 2023. And if we are to count the number of ballots that had not been printed during this period from October 10 to the present, then if we are supposed to print 3 million ballots per day, 12 days, then that will be about 36 million ballots, Your Honor. And from now to the conduct of election by December 5, it's almost at least 44 days. Definitely, Your Honor, will not be able to finish printing the ballots. Now, as regards the other election paraphernalia, such as, for example, indelible ink, we had been preparing for the procurement of indelible ink. But however, indelible ink will be expiring by 1 year. And so if we will proceed with the procurement of indelible ink even after the signing by the President on October 10, then, and there is already a law which says that the election is postponed, then definitely by next year, all of this indelible ink will dry up. So surely we will not proceed with the procurement of the indelible ink. Such other election paraphernalia, Your Honor, we have a legal issue. And the legal issue is whether we can legally proceed with the procurement despite the postponement of the election. And so we instructed our law department to inquire and to make a recommendation to the COMELEC and Bank what the COMELEC and Bank will be doing as regards the pending award of contract, the pending the notice to proceed, because we do not want to violate any auditing rules, and we do not want that COA will be giving notices to the Commission as far as these awards are concerned. So we are in a dire predicament, Your Honor. So material time, we do not have anymore, Your Honor. It's really not viable and feasible at this time.
Thank you, Chair. I have no further questions. Thank you, Petitioner Macalintal, for your answers. Thank you, Solicitor General, for your answers. Thank you, Chair. Thank you for further questions. Thank you.
Ayan. So, yung napanood nyo po, mga idol at mga bayan, yun po yung bahagi ng oral argument noong 20 ko na po kanina na yung panonoorin po natin ngayon ay 22, mga idol at mga bayan. So, doon po sa oral argument ay nanalo po dyan si Attorney Romulo Macalintal, kung kaya nga po ay naideklara na unconstitutional, labag sa batas, yung postponement noong 2022. So walang pinagkaiba po yan mga idol at mga bayan sa ginawa nilang batas ngayon. Na bagamat term setting yung nakalagay, yung magiging epekto ay postponement po talaga nitong December 1, 2025. So antayin na lang po natin kung ano po yun pong magiging desisyon ng Korte Suprema patungkol nga po dito sa postponement ng December 1, 2025. So kung bago pa lamang po sa aking channel, sana po ay huwag niyo pong kalimutan mag-subscribe para ma-notify kayo kapag meron ng update yung Supreme Court mga idol at mga bayan. Pindutin niyo lang po yung subscribe dyan po sa baba. So hanggang dito muna yung ating update at maraming salamat po sa inyong panonood. God bless po sa ating lahat. Thank you so much po.